Hi, y'all, and welcome back. If you're new here, welcome and glad you found us. I am JoJo, and it is great to meet you. We are about to talk about another true crime case and hopefully see justice be done. But before we do, please hit that like button. And if you haven't already, click subscribe and turn your bell notifications to all so you can make sure to be notified when I post new videos. Thank you, everyone, for all your support. It means the world to me. Now sit back, kick off your shoes, grab your tissues and stress balls, and let's dive in. The content you are about to watch contains the subject matter of a real-life true crime event. Therefore, it is not suitable for all ages and is only intended for adults. Hi, y'all. It's JoJo, and welcome back. If you're new here, welcome aboard. And I will be down there in the chat because guess what? This is my first premiere video. Yay! I wish I had one of those sound effects there that is clapping hands. But hey, there we go. That's my sound effect for today. Anyway, moving along here. And if y'all read the description down below, you'll see I got quite a treat in store for y'all. I had to pay for it, mind you, but I ended up getting my hands on the court reporter's transcript. I got it directly from the court reporter, and it is the transcript of the hearing where Jake and Vanessa were sentenced for what they had done to the innocent little 10-week-old daughter that they had together. Yes, you heard me right. 10 weeks old. I mean, how in the world can anybody look at a 10-week-old and get that mad at a child, or even get it anywhere in their head to do what they did to this innocent little baby? And I say they because they were both convicted, but I think we all pretty much know, and based on statements that we have heard from the actual arrest record and affidavit, that, yeah, it wasn't Vanessa, but she wasn't completely innocent in all this. She still had some culpability in this, but the one who actually did the damage was Jake. So he's the biggest monster of all. And now, unfortunately, I believe he is the one who has unalived Emmanuel. That's just my opinion now, so don't come after me, but which I know we're all thinking it. We don't want to think it. It's worst case scenario, but I do believe, unfortunately, Emmanuel is no longer with us. I wish I could believe differently, but unfortunately, I can't. My head says logically he is no longer with us. So we're going to go ahead and we're going to move on to the transcript. This is from the Superior Court in the state of California, the county of Riverside. And it is the people of the state of California versus Vanessa Avina and Jake Mitchell Haro. And here are the case numbers right here. One is Vanessa's and the other is Jake's. And this is the reporter's transcript of proceedings. And this is held before the Honorable Dwight Moore, Department 65. In other words, in California, for those who do not know, instead of just calling them Courtroom 65, they call them Department 65, which who knows why they do that. They just do. To each your own. And this was done on June 8th, 2023. Sure that if you're here, you've probably been to the press conference or seen the press conference already that happened here recently, the past couple of days ago. I can't remember the exact date right off the top of my head right now, but it was a couple of days ago or a few days ago. It was sometime last week, because right now is actually September 1st that I'm doing this recording, even though y'all won't actually see this until September 3rd, Wednesday. I was originally going to do this on September 2nd, but something came up. If you read my post within my YouTube channel, you will see I talk about that. Anyway, moving on. Honorable Judge Dwight W. Moore, he actually ended up retiring from the bench from full-time service in 2021 from San Bernardino County, and he was actually appointed to the bench in 2007 by then Governor, wonderful Mr. Arnold Schwarzenegger, and he had continued to handle temporary judicial assignments. And apparently, this was one of them that he decided to handle. And oh, how I wish that he did not handle this one. But either way, we cannot change the past. The past is the past, and there's nothing we can do about it. So I'm sure that he is probably kicking himself in the rear end right about now and wishing that he would have never either stepped foot on this case or been this lenient with the monster at hand. But either way, it happened, and there's nothing we can do now about it other than just learn from it. So we're going to go ahead and we're going to move on, and we're going to hopefully learn from this situation, and hopefully this will never happen again. And California will start tightening its belt a little bit on these monsters and not let them get just a slap on the wrist. So we're going to move on, and we're going to talk about this transcript here. So for the plaintiff, we've got the Office of the District Attorney, and that is going to be Sam Taloa. I hope I'm saying that right, and I'm so sorry if I am not. And then for defendant Avina, which is Vanessa, she went to Greach, Packer, and Hanks, and her attorney is actually Joshua Hanks from that attorney's office. And then for defendant Haro, he went to the law office of Vincent S. Hughes. His actual attorney is Vincent Hughes, which we've seen Mr. Hughes' face all over the media here recently, talking about how they were cooperating with the LE. But yeah, either way, not gonna go there. And special by Randy, we're gonna go with Sarmento. I hope I'm not butchering that one too. So June 8th, 2023, we're working on the morning session, and this is before the Honorable Dwight Moore. He did both cases, and we start with Vanessa. She was the first case. So the court, Vanessa Avina, Mr. Hanks. Good morning, Joshua Hanks for Miss Avina. She is present, out of custody. Mr. Taloa. Good morning, Your Honor. Sam Taola for the people, Mr. Hanks. Your Honor, this was a case we had discussed a couple weeks back, and your indicated was a 17B with the probation terms that I've indicated there. Now, I went ahead and I looked up what a 17B is. And a 17B is a motion. In California, Penal Code Section 17B allows for the reduction of certain felony convictions known as quote-unquote wobblers to misdemeanors, provided the court finds it appropriate after considering factors like the offense's nature, the defendant's conduct, and their prior record. This reduction provides significant benefits, including easier employment and licensing opportunities, restoration of voting rights, and the ability to possess firearms. A formal 17B motion can be filed at various stages of the legal process, such as before a preliminary hearing or at sentencing. So what is a wobbler? A wobbler is a criminal offense that can be charged as either a felony or a misdemeanor, depending on the circumstances of the crime and the defendant's history. Examples of wobbler offenses include assault with a deadly weapon, grand theft, and embezzlement. Nowhere in there do I see anything about child endangerment or that other word. So I don't understand exactly why she ended up getting to file this motion. But like I said earlier, she is culpable in this crime, but I do not believe that she actually laid hands on the baby and did any physical damage to the baby. So we're going to go ahead and we're going to move along. We can't change the past, just like I said earlier. The court, and this is a plea to the court, Mr. Hanks. It is, Your Honor. And we had also discussed, because she is required to do the 52-week child batterers course, whether or not the court would be inclined to give her credit if she had already done the course. I submitted proof that she's done 40 classes of the 52. She's spoken to the class, and they're amendable to allowing her back in if the court is okay with that. The court. What I would do in a situation like this, counsel, is order her to do the full 52-week course and indicating that it is up to the program as to whether or not they believe it's appropriate to give her credit for what she's done or whether she needs to start again. I'm leaving the decision to them. Mr. Hanks. Perfect. Could we just have it reflected in the minutes that the court has no objection to that? The court. Yes. Mr. Hanks. Thank you. The court. All right, Miss Avina. I've received a form from you entitled, quote, misdemeanor plea form, end quote. I'm showing you the form. Did you read this entire form? Defendant Avina. Yes, sir. The court. Did you place your initials in each of the boxes and sign the form on the last page? Defendant Avina. Yes, Your Honor. The court. The form indicates that you're going to plead guilty as charged to count 1. Penal Code Section 273A, subsection A, child. Based on your decisions, I have decided that I would accept a plea to a misdemeanor, although the district attorney has charged it as a felony. What I indicated is you'd be placed on probation for a period of 4 years. It's informal probation. I'd order you to do 120 days of work release, weekend work release. You're eligible for half-time. That may be pick up the garbage by the side of the road or whatever else they have you do. You have to attend and complete a year-long child program. I said it before, and I'll say it again on the record. I'm told you've done most of the program already. I will not object if the program decides to give you credit for the classes you've already done. Also, if the program says no, you need to start all over and do it straight through, that's okay too. That's up entirely to the program. I'm leaving that up to them. And restitution, if there's any bills you need to pay as a result of this, we'll deal with that down the road. Is that your understanding of the agreement? Defendant Avina. Yes, Your Honor. The court. Is this what you want to do? Defendant Avina. Yes, Your Honor. The court. To the charge of child, section 273A, subsection A, as a misdemeanor, how do you plead? Defendant Avina. Guilty. The court. Counsel join? Mr. Hanks. Join. The court. I'll accept the plea. In this matter, I'll impose pronouncement of judgment. The imposition of sentence will be suspended for a period of 4 years. The terms of probation include 120 days, weekend work release. Do we have any probation? Yes, we do. They are telling you to report to sign up for your weekend work release no later than July 7th. There's a restitution fine of $150. In the program, there may be other terms. There's a set of probation terms here. Did you read all the probation terms? Defendant Avina. Yes, Your Honor. The court. Did you go over them with your lawyer? Defendant Avina. Yes, Your Honor. The court. Understand them all? Defendant Avina. Yes, Your Honor. The court. Any questions? Defendant Avina. No. The court. Either about your probation terms or anything else? Defendant Avina. No. The court. All right. Then in that matter, you are on probation. This is informal probation. You don't have to report to probation. You won't have a probation officer, but you need to do the program. File proof that you've completed the program no later than August 1st of next year. If they're only going to make you do 10 or 12 more classes, you'll be done and be able to file proof a lot sooner than that. But if you have to start over from scratch, you've got until August 1st of next year to file proof. If you're done sooner, file proof as soon as you're done with the clerk's office downstairs. That will be the order. Mr. Hanks. Thank you, Your Honor. Defendant Avina. Thank you, Your Honor. Other matters heard. Now, we're going to go ahead and we're going to move on to the afternoon session of June 8th, 2023. And this is when they go on to Jake's case that most glorious monster. The court. Let's call the matter of Jake Haro. Mr. Sarmentio. Good afternoon, Attorney Randy Sarmentio, Sarmiento, specially appearing for Attorney of Record, Mr. Vincent Hughes, Hughes. The court. Good afternoon, Mr. Sarmentio. Good afternoon, Mr. Teola. Good afternoon, Your Honor. Sam Teola for the people. The court. Thank you. Mr. Haro. Good afternoon, sir. Why does he have to call him sir? He's a monster. He's not a sir. Anyway, I know he has to show some respect, but he didn't call Avina miss or ma'am or madame. How come Haro gets more respect than she did? He's the one, in my opinion, who ended up doing the physical damage. I digress. Moving on. Defendant Haro. Good afternoon. The court. Mr. Haro, I have received from you a form entitled, quote, felony plea form, end quote. I'm showing you the form, sir. Did you read the entire form? Defendant Haro. I did. The court. Did you place your initials in each of the boxes? Sign and date the form on the last page? Defendant Haro. I did. The court. Did you understand everything on this form, including all of the legal rights and all the penalties, punishments, and consequences of entering this plea that were listed on the form? Defendant Haro. I do. The court. Do you understand, sir, that if you plead guilty in this case, you will be giving up some of those legal rights? Those include your right to a speedy and public jury trial, your right to confront and have your attorney cross-examine the witnesses against you, your right to subpoena witnesses and evidence in the court on your behalf, and your right to remain silent. Are you willing to give up each of those rights so you can enter into this plea? Defendant Haro. I do. The court. My understanding of the plea is that you are pleading as charged to count 1, Penal Code Section 273A, Subdivision A, child endangerment. This is a felony. The agreement is that I would sentence you today to 6 years in state prison. I will then suspend execution of that sentence, placing you on formal probation for a period of 4 years. Terms will include 180 days as a term of probation. Is that your understanding of the agreement? Defendant Haro. I understand. The court. Other than what I just read to you, has anyone made any other promises to you to get you to enter this plea? Defendant Haro. No. The court. Has anyone made any threats to get you to do this? Defendant Haro. No. The court. Are you under the influence of any alcohol, drugs, or medication right now? Defendant Haro. No. The court. Have you had enough time to discuss your case with your lawyer, including your legal rights, defenses to the charges, and the consequences of entering into this plea? Defendant Haro. I have. The court. Are you satisfied and do you understand all those things? Defendant Haro. I understand. The court. Do you also understand if you're not a citizen of the United States, the consequences of this conviction will include deportation, exclusion from the admission to the United States, and denial of naturalization? Defendant Haro. I'm a citizen. The court. You also understand that if you are placed on probation, there will be a long list of probation terms? Defendant Haro. I understand. The court. Counsel, have you had enough time to discuss all these issues with Mr. Haro? Mr. Sarmentio. Yes, Your Honor. The court. Did you go over the change of plea form with him? Mr. Sarmentio. Yes, Your Honor. The court. Are you satisfied that he understands everything on the form? Mr. Sarmentio. Yes, Your Honor. The court. Do you join in his waivers? Mr. Sarmentio. So joined. The court. I'll find the defendant has read and understands his change of plea form. He understands the nature of the charges which he's pleading, all punishments and consequences for that offense, and each of his constitutional rights.
I'll find he has knowingly and intelligently, freely and voluntarily waived each of those rights. Sir, is your true name Jake Michelle Haro? Yep, his name is Jake Michelle Haro. I'm sorry, I shouldn't be laughing. I do apologize. Defendant Haro. No, the court. What is it? Defendant Haro. Jake Mitchell. Mitchell. I just feel like he would have had that like attitude about him, like, how dare you call me Jake Michelle? I'm sorry. I shouldn't be laughing. I do apologize again. The court. We have it misspelled. The correct spelling of the middle name is M-I-T. Defendant Haro. Yes. The court. Okay. Mitchell. Is your true name Jake Mitchell Haro? Defendant Haro. Yes, Your Honor. The court. AKA in case BAF 2101265. The charge in count 1, child endangerment, Penal Code section 273A, subdivision A, as a felony. How do you plead? Sorry, my AC just kicked in again. I do apologize about that. Defendant Haro. Guilty. The court. Counsel, join in the plea? Mr. Sarmentio. Yes, Your Honor. The court. And this is a plea to the court. The people are not joining, correct? Mr. Taloa. Correct. The court. All right. Counsel, are you willing to stipulate? Has this case been to prelim yet? Mr. Taloa. No, Your Honor. The court. Are the parties willing to stipulate that if I refer to the police reports in this case, I would find a factual basis for this plea? Mr. Taloa. Yes, Your Honor. Mr. Sarmentio. Yes, Your Honor. The court. I find the defendant has personally and orally entered this plea in open court. The pleas are free and voluntary, knowing and intelligent. There's a factual basis which I'll accept and confirm. Sir, you have a right to have me postpone your sentencing. Refer your case to probation for a pre-sentence investigation and report, and be back for sentencing within 2 days. My understanding is you wish to give up those rights and you want me to go ahead and sentence you right now. Is that what you want to do? Defendant Haro. Yes, Your Honor. The court. Counsel, join that waiver? Mr. Sarmentio. So joined. The court. Waive arraignment for sentencing? Mr. Sarmentio. No legal cause. The court. I'll make the following findings. Was a motor vehicle involved? Mr. Sarmentio. No, Your Honor. The court. A motor vehicle was not involved in the incidental commission of this offense. Actually, before I go any further with the findings, I'm going to do this. Probation is denied. There's one other thing here. In addition to the plea, are you stipulating, sir, pursuant to Rule 4.421A3 of the California Rules of Court, that the victim in this case was particularly vulnerable? I'm going to look that up. I will be right back because, first of all, probation is denied. Now, I know that there's got to be a little twist in there somewhere because we all know that probation was not denied because that's what he ended up getting instead of the sentencing. Give me a minute. I'm going to go look that up and I will be right back, y'all. All right, y'all. I'm back. Did you miss me? Probably not, being that I'm editing that part out, so y'all wouldn't even notice that I was gone. Anyway, so what that is California Rules of Court, Rule 4.421A3, specifies that a crime is an aggravating factor if the defendant took advantage of a position of trust or confidence to commit the offense, as listed in subdivision 3 of the rule, which includes committing the offense while in a position of special trust or confidence. The rule applies when a judge is deciding whether to impose a sentence exceeding the middle term, as these are factors that make the offense, quote, distinctively worse than the ordinary, end quote. So that makes total sense in my opinion because, yeah, he was the father, so he was in a position of special trust and confidence because the baby doesn't know any better. I mean, the baby looks at him as he was her caretaker. And of course, that's a special kind of trust that, yeah. Anyway, y'all know what I'm saying. I'm moving on. This is just a sad case all the way around, regardless of how you look at it. Defendant Haro. Yes, Your Honor. The court. Counsel join in the admission as well? Mr. Sarmentio. Yes, Your Honor. The court. All right. Then on that basis, probation is denied. Based on the defendant's stipulation in the plea agreement with the court, the defendant is sentenced to the aggravated term of 6 years in state prison. Okay, but he didn't actually serve 6 years in state prison. I want you to let that sink in for a minute. I just sentenced you to 6 years in state prison. I will then suspend execution of that sentence and place you on supervised probation for a period of 4 years. But if you violate your probation, you've already been sentenced to 6 years in prison. There will be no argument about, well, that's too much. Maybe we should give him less. No, you've already been sentenced to 6 years. Do you understand that? Okay, so in a way, was the judge trying to say, okay, you screw up and you're going to you're getting this 6 years and there's no way to appeal it, basically? And that's the reason why he went ahead and did this plea deal? I don't know, that kind of brings it into a different perspective for me. I mean, what do y'all think out there? Does that kind of put it into a new perspective for you? And does that kind of make you rethink the anger towards the judge a little bit? That the judge was trying to kind of give him the benefit of the doubt, and at the same time making it to where that if he did screw up, that he would still get the maximum that the judge could possibly give him for the charge that he was charged with? That's interesting. Because from what I understand, with the count that he was actually charged with, 6 years would have been the maximum sentence that could be imposed on him. I have to dive a little bit deeper into that. But that is my understanding anyway. So you know what? Let me pause this for just a minute. And I'll be right back because I want to look into that. Be right back, y'all. Okay, y'all. So I'm back. And of course, you didn't even miss me because you didn't even know I was gone. Because I just cut all that garbage out where I went and did my digging. So anyways, I found out that in California, a felony conviction under Penal Code 273A, subsection A, in 2023 carried a maximum sentence of 2, 4, or 6 years in state prison, depending on the circumstances. Penalties also included a potential fine of up to $10,000, formal felony probation, and could trigger a quote-unquote strike under California's 3 strikes law if the child suffered great bodily injury or unaliving. And then it says maximum prison sentence. The maximum sentence for a felony conviction was 6 years in state prison. So, yeah, that was the maximum that Jake would have been able to receive at that time. So, in other words, he's making it to where Jake, if he screwed up, would not be able to appeal that 6-year sentence. So now I'm kind of torn. I don't know. What do you guys think? I mean, he's giving him the max sentence, but he did suspend that sentence. Let me go back and look. So penalties also include a potential fine of up to $10,000, formal felony probation, and could trigger a strike under California's 3 strikes law. Okay. So does that mean that he could have had the 6 years in state prison plus the felony probation and the $10,000 fine? Because that would be the extreme max, right? Or is it that he could only do the maximum prison sentence or the other penalties? That might be more of a lawyer question. 2, 4, or 6 years in prison and or up to $10,000 fine. Courts can grant probation in lieu of jail. Okay, so he can't give him both. Either give him the years in prison and or up to $10,000 in fines, or grant the probation in lieu of jail. Let's see what the max felony probation is. Okay, so felony probation can last up to 5 years. See, now this is messed up. Right here it says probation is the standard sentence for most misdemeanors such as DUI and drug possessions, as long as you 1, don't have an extensive criminal history, and 2, pose no public safety risk. He poses a major public safety risk, in my opinion. I mean, that's what we're seeing now, correct? If prosecutors refuse to agree to probation as part of a plea bargain, your criminal defense attorney can always ask the judge at your sentencing hearing to grant you probation. You can even introduce character witnesses and other evidence to sway the judge's decision about your eligibility. Okay, consequences of violating probation. If the judge finds at the PVH that you did intend violate a term of your probation, they have 2 choices. Seriously? So PVH is a probation violation hearing. Wow, we're really going down the rabbit hole now, aren't we? Okay, so you know what? We're going to do this. First, finish up this transcript. And then once we finish up this transcript, we're going to go over and we're going to talk about probation and kind of understand this a little bit better and talk about the reason why his sentence was not immediately unsuspended and he was not immediately thrown into jail the minute that he was arrested for the violation of probation. Because I just found some interesting information on this lawyer website that I was just looking at. So let's go ahead and we will finish up the transcript, and then we will go over and dive more into the actual information on the probation and how that all works with a suspended sentence. So where were we over here? Okay, we were right here. Yeah, where he just told him about, you've already been sentenced to 6 years. Do you understand that? And then defendant Haro says, I do, Your Honor. And then the court, all right, then I'll suspend execution of that sentence. I'll go back to make my findings. I'll order the defendant to pay court fees $40 plus $30 for a total of $70, as well as a victim restitution fine of $300. That's a total of $370. I order you to pay at the rate of $25 a month with your first payment due August 15th. Can you handle that? That's it, a measly $300 victim restitution fine? You serious? Anyway, defendant Haro, I can. The court, that will be the order. I'll also impose a probation revocation restitution fine of $300, stayed pending successful completion of probation. That means you don't have to pay the last $300 fine unless you violate your probation. Well, guess what, Jakey boy? You're paying an extra $300. Not like it really freaking matters. If you violate your probation, you have bigger problems than the $300 fine. Amen to that. The terms of the probation include a year-long, I can't remember the name of the program, the Child Batterers Program. You must file proof by July 10th that you've enrolled, proof by July 22nd of next year that you've completed the program. File proof with your probation officer. Also, 20 hours of community service through a nonprofit. File proof that you've completed that before July 22nd of next year. You have a year to do 20 hours. That shouldn't be too hard. You're ordered to do 180 days. You're eligible for weekend work release. You're eligible for halftime. I'll order you to report to any Riverside County jail by July 15th of this year to get that weekend time done. Again, you've got plenty of time to get it done. There are more terms of probation. I have not read all of them to you. Did you read all of your probation terms? Well, y'all, since this ended up being a lot longer of a video than I originally intended for it to be, I'm going to go ahead and cut this here. We will come back tomorrow with another premiere video. Part 2 will start with being that the judge just ended up talking about the probation terms, but he didn't go into full detail on all of Jake's terms, I will put up the document with all of the probation terms so that we can walk through all of his probation terms together. That way then we get a full understanding of exactly what his restrictions were as far as probation goes. And then we will go on from there and we will finish up with the transcript. And if we have enough time, we will move on to the probation information. If not, we may do a third video. Now, tomorrow will be Friday because I am putting this out on Thursday, even though I actually recorded all of this like back on Monday, I believe it was. But I'm putting this out Thursday, and then for the first part, and then the second part will come out on Friday. Now, if we do a third part, then that will possibly come out on Saturday. I will have to let you know at the end of the second part if we need to go into a third part. But thank you so much for all of your support and for keeping Emmanuel's story out there and in the public and keeping the pressure on the officials to get justice for Emmanuel, because that is the number one purpose in all of this. Not to mention, we get justice for Emmanuel, we're also getting justice for Promise Faith at the same time, because to be perfectly honest, she never received her justice either. Not really, because he just got a slap on the damn wrist. But anyway, we're not going to go there right now. We're going to go ahead and end this video now, and I will catch y'all on the flip side, and I can't wait to talk to y'all in chat. So y'all stay safe, stay happy, bye-bye y'all.